I move that leave be granted to introduce this bill. With your permission. I welcome the opportunity to introduce this bill to the Dáil. It is a bill to amend the Planning and Development Act. It specifically obliges in law a statutory time period of 12 weeks by which An Bord Pleanála is obliged to make a decision on planning applications it receives or appeals made to it on foot of local authority decisions. Local authorities themselves have 8 weeks to initially grant, refuse or seek clarification on files, and a further 4 weeks in the case of receipt from further information thereafter. The applicant has no more than 6 months to respond to further information requests, so therefore an application process can take at least 13 weeks or 3 months, and at most 37, 38 weeks, 9 or 10 months. There is no way that An Bord Pleanála should be taking so much longer, and in many cases 18 months, 2 years, 3 years. No way that what happens in local authorities in 3 months should take that long with An Bord Pleanála. Therefore, this bill seeks to rectify that fact, and this is the means by which it can and should be done. We're in the midst of a housing crisis. Everyone accepts that solving the housing crisis is complex and multifaceted. We appreciate that a major issue is supply. We recognise that a major solution is increasing supply. Supply is restricted and slowed down and impacted by planning, by cost of construction and by bureaucracy in the way in which local authorities liaise with the department in the construction of homes. In this bill, I can only seek to rectify An Bord Pleanála's role, and I want to ensure it doesn't continue to unduly delay the provision of supply. Similarly, though, the government could and must put on a similar fashion statutory time periods and constraints on judicial reviews and subsequent appeals too. And despite the best laid plans, policies, initiatives, bills and motions indeed by government and indeed opposition, they are all subsequently at the behest of the planning process. And I don't want to disregard or belittle, of course, the process of adjudication and deciding on applications. It's transparent, it's independent, it's cognizant of development plans, of strategies, provisions relating to best practices in design standards, in engineering, in architecture, health and safety, environment and many other aspects. I don't either want to disregard the subsequent right of appeal, which can further challenge the initial decisions, but all such aspects of the system must be time limited and therefore not unduly delay or put in danger the very projects which are seeking to address these issues. I want to mention An Taisce, if I could, in relation to the debate that's ensuing this week as a result of the High Court decision and the subsequent threat of appeal and a point of law on the part of An Taisce to that decision. An Taisce or any of its staff or its supporters or members of the public who support it can, of course, have an issue with government policy. And that's fair play and that's understandable and that's as it should be. But to change government policy, it has a remit to lobby and advise. And anyone else who wishes to change government policy can influence it by being elected to this chamber. They don't or shouldn't be allowed to usurp, frustrate the likes of the Glanbia project based on it having been approved on merit pertaining to planning laws, resolutions, regulations, guidelines and provisions by Kilkenny County Council, by An Bord Pleanála after a protracted delay, and by the High Court, who in their decision stated recently that Taisce's issue is an issue of government policy. Such procrastinations and delays has a major impact on this country's ability to respond to housing supply shortages and to our region's efforts to provide investment and sustainable development to replace other industries, and in this case, to deal with the offshoot of Brexit and its implications. So I'd ask government to accept this bill in the first instance and to address other issues mentioned too, in asking, not simply asking An Taisce not to proceed with an appeal, but by addressing and putting in place the correct measures in law and in legislation to ensure that nobody has the right to usurp or procrastinate or delay worthwhile developments, as was the case in this instance. I commend the bill to the Dáil, and I would hope, as I said, all parties would support it and contribute to make it better and do what we wish it to achieve. Thank you.
Is the bill being opposed? No. Okay.
So, not opposed.
Not opposed. The motion for leave to introduce is agreed, and I would ask the Deputy to move that the second stage be taken in private members' time.
I so move.